The justices will not rule on the legality of the death penalty. Instead, they'll consider if a U.S. federal appeals court correctly overturned the conviction and death sentence for Hector Ayala, ruling he was denied a fair trial because of the absence of Black and Hispanic jurors. Here with what's at stake are my guest, Alex Simpson, adjunct professor at California Western School of Law, and constitutional law attorney Dan Eaton. Welcome.
Thank you.
Thanks.
Now, Alex, the Ninth District Federal Appeals Circuit ruled that Ayala was denied this fair trial because of the makeup of the jury. Explain their argument.
So essentially, that you have a constitutional right to essentially a diverse jury, and a prosecutor can't strike jurors from the jury box just because they are of African American or Hispanic or of a different race than you. And so that was the challenge, was that the prosecutor in this case struck all of the people who are of African American or Hispanic, and left with an all-white jury. And so that was the challenge that was raised on appeal.
And that's what the Supreme Court may be hearing come next year, Dan. So what kind of ruling can we expect on this type of case?
Well, following up on what Alex said, the critical question was when the prosecution was brought before the judge to explain the neutral reasons they had struck those African American and Hispanic jurors, the defense counsel was excluded. And so Mr. Ayala is saying, wait a minute, that isn't fair, and you can't have a death penalty with a juror impaneled in that manner that's consistent with my procedural protections under the Constitution. That is what is before the U.S. Supreme Court, as you said, not the validity of the death penalty itself.
So do you have any idea of which way this ruling might go, or is it just for...
It's really a fool's game to bet on how the Supreme Court is going to rule. It takes 4 people to grant review, and it'll be very interesting to watch.
Well, Alex was agreeing with you on this, and let's say the ruling rules in favor of the Ayala case. What would happen then?
So if the United States Supreme Court comes down with a decision saying that the Ninth Circuit reversal of the death penalty in this case was okay, then that means that Mr. Ayala gets to be retried, or at least the prosecutor decides whether or not to retry the case. They don't have to, obviously, and they may not. This conviction happened in 1989. There may not be enough evidence at this point to re-prosecute and reconvict.
Could he go free?
He could.
He could, okay. Dan, the case brings to light the death penalty. It brings it back into the spotlight here. And this summer, a federal judge ruled that the state's death penalty law was unconstitutional. What were some of the reasons behind that ruling?
Well, because the way California administers the death penalty is arbitrary, there are too many delays that are involved. Understand that since the death penalty was reinstituted in 1978, very few people have actually been executed, fewer than 20. And 63 have died of natural causes who have been sentenced to death. And it's because it is, as the judge's word, freakish as to who actually gets executed under California's death penalty law that it's inconsistent with the 8th Amendment prohibition on cruel and unusual punishment.
Well, let's talk about that, Alex, because I know, first tell us how many condemned prisoners are there to death here in California, and what will this impact, or has it been, should I say, on those on death row? Are they on a stay? Nobody can be charged with executions. Explain that for us.
Yeah, so there's 700 and change people who are on death row in California. Dan's absolutely right. There's only been 13 who have actually been executed since 1978. So it's a very small number of people who actually are executed versus the large portion of people who are on death row and who either get their convictions reversed or die of natural causes. That's usually that's more likely what would happen if you're actually sentenced to death in California. So, what this decision would mean is potentially we could not have a death penalty in California, not because of a voter-approved law, but because some judges have decided that.
But there are other states that actually have sped up the process. So is that, I'll start with you, Dan, is that something that could happen to speed up the process of these executions?
It could happen. In fact, a trio of former governors tried to get a ballot initiative to try to do exactly that, but were unsuccessful in the petitioning process. So the Ninth Circuit certainly could say, what you need to do is go back and see whether this can be fixed and whether California is willing to fix it. It's not entirely clear what could happen, but you're certainly right, Peggy, to talk about the range of options that the Ninth Circuit has before it.
And Alex, let's end on this with you with that same question. Is it possible that people could just speed up the process and thereby sort of eliminating this argument that it's cruel and unusual because they're waiting so long on death row?
The problem with speeding up the death penalty is that it is inherently a dangerous proposition. What we have are people who have been wrongfully convicted executed who get out through DNA, for example, off of death row. And so if you speed up the process, you're speeding up the likelihood that there's going to be somebody who's innocent who's executed.
All right, Alex Simpson and Dan Eaton, thank you very much.
Thank you.